And shortly, we'll be joined in studio by Dennis Poaberi Wedam, Esquire, to help us break down the final judgment or the full judgment of the Supreme Court on why they decided to dismiss the injunction application that was applied by Member of Parliament for Old Tafo, Vincent Eko Sifua. That is the second major story that we have for you this evening. And later, we'll also tell you how senior high school infractions and the recent uptake of students taking up arms and going onto school campuses with all sorts of weapons. You know, for whatever reason, it has become quite topical. School authorities are concerned about it. We've heard executives of the Ghana National Association of Teachers threatening that if the situation does not come to a halt, they, teachers, may also have to arm themselves when they are going to campuses. But we don't want to get there, so we'll try and get some perspectives to that issue while the bulletin goes on. So let's go to the courts now. And on the 6th of May 2025, the Supreme Court dismissed an injunction sought by Member of Parliament for Old Tafo Vincent Eko Sifua against commencement of proceedings to hear 3 petitions to remove Chief Justice Gertrude Torkornoo. The 5-member panel, in a 3-2 majority decision, dismissed the injunction brought by the Old Tafo Member of Parliament. Well, in the full reasoning by both the majority and the dissenting justices, an 81-page reasoning was released, dated Friday, May 23, which is actually today. What exactly is contained in the 81-page document or reasoning by the justices of the Supreme Court? Joining me in studio now is Dennis Poaberi Wedam, Esquire, who has been combing through it to help us make sense of it as laymen. Dennis, good evening. Thank you for joining us.
I am pleasure to be here, Martin.
What would, so to the ordinary Ghanaian, we know that the Supreme Court dismissed the application that was being sought by Vincent Eko Sifua. So what are the nitty-gritties in this particular reasoning?
Well, Martin, let's start off from the top to understand who said what in that decision. So you did indicate that it was a 3-2 majority decision. The 3 saying that no, we cannot uphold the application for that injunction that Vincent was seeking to restrain the committee that was put into, the processes that were ongoing to, seeking the removal of the Chief Justice. This was on the basis that he had made the argument that the Chief Justice ought to have been given copies of the petition first off, her response elicited before any other step could be taken. And that to the extent that that was not done in his view, the court, it was a violation of the Constitution for which the court needed to put the processes on hold. Now, after hearing both sides, Justice Bafo Boni, who then was the acting Chief Justice, Justice Amadou Tanko, and then Justice Yoni Kolendi, they were those who disagreed with that application by Vincent. The 2 on the other side, who are the dissenting justices, are Justice Professor Mensah Bonsu and then Justice Jew. Now, let's begin with those who say that no, we cannot uphold that application, or in other words, we cannot grant what your wish is before the court. Now, Amadou Tanko, who has actually written the judgment for those who have disagreed with Vincent, that's to say those on the majority, he begins by first trying to evaluate the evidence on record and to set out what the law is when it comes to the grant of applications. The first question that the court usually asks is there a serious question to be answered? That's the beginning point. So they evaluate all the things that have been put before the court to see if indeed there's a question to be answered before they even begin to go into the other matters. They characterize the entire application to mean that Vincent was basically making the argument that the president had decided to take an action or to begin the consultation with the Council of State towards the removal of the Chief Justice without first giving her the petitions and asking for her response. Now, these are matters that are verifiable because they attach some documents that show, for instance, the beginning of the process where we had an announcement from the presidency indicating that some 3 petitions had been received from members of the public, and that same had been forwarded to the Council of State for the process to begin in accordance with Article 146. Now, again, when they look at the date that Vincent filed the application, which was 2 days after this particular announcement. So the announcement was on the 25th of March. Vincent's application was on the 27th of March. Now, a day after, there was also a letter from the Chief Justice also requesting for copies of the petitions to answer. She also made a similar argument as Vincent that she ought to be given the copies, of course, to be notified and be given the copies to get her response. So when they look at the sequence of the events, it is the view of the majority in the lead judgment by Justice Amadou Tanku that the letter that came from the presidency was not in fact the commencement of the process. It was an announcement of the commencement of the process. And that's when you look at the documents as were presented, and even with the request that the Chief Justice herself made to get copies of the petitions and also give her response, it did indicate that indeed she got those documents which formed part of the things that the President together with the Council of State used to determine the prima facie case. So in making that analysis, they got to a point that even the applicant or plaintiff in this matter, Vincent, actually misconceived what really the essence of that communication was, because his view was that the announcement from the presidency was the beginning of the process. But as the court reasoned, that was not the beginning of the process. And that what he was actually complaining of was actually taken care of because, one, the presidency had actually written to the Chief Justice to tell her that this is what we are doing. We receive petitions, we are forwarding same to the Council of State, intending to do ABCD. All those things were on record.
Okay. Let me just come in here for purposes of clarity.
Yeah.
So is it that before the presidency had written to Madam Gertrude Torkornoo,
yes,
and informed her of the intentions or the decisions they intend to take?
Yes.
Is that part of the process that the justices were talking about? Because the thinking is that Vincent Akrofi says that the decision of the government communication spokesperson to come and announce publicly that some petitions have been given to the president, and on the back of that, the president has forwarded same to the Council of State, was the initiation of the process of investigation. But that's not what the justices are saying. Is that so?
So the justices are saying, you contend that the process did not follow a certain sequence, and that by announcing that the petitions had been received and forwarded to the Council of State, it meant that the consultation process had already begun.
Okay.
Part of which included the determination of a prima facie case. And on that score, he argued that it was unconstitutional.
Okay.
However, the records show that the letter that was issued from the presidency was just a letter announcing that these petitions had been received and that same had been forwarded to the Council of State. There was also another letter on record to the Chief Justice indicating that we have received petitions. We have forwarded same to the Council of State. We are giving you an opportunity to respond to this. That aside, the Chief Justice herself wrote a letter requesting for the petitions, which she was given. Remember, she asked for 7 days, the president gave 10 days. They are saying that all those things happened before the determination of the prima facie case.
Okay.
And that to that extent, even right from the word go, Vincent may have misconceived the whole sequence of the event.
Okay.
To have thought that the beginning of the process started off without even hearing from the Chief Justice.
Okay.
So since that was set aside, if you followed keenly, then you would have not set aside per se, but since that was
established by the judges
to be flawed, then it meant that in their view, there was not even a serious question to be tried.
Okay.
However, they will still go on to consider other things, to see that the other thing that they will consider is what harm will be caused, so much so that that harm cannot be repaired if we are allowing the process to continue till the final determination of the case.
Okay.
They say that on the record, counsel for Vincent did not say much on that. In fact, he had said that that question only arises when it has to do with human rights matters. But because this was a constitutional matter, in his view, that does not arise. The court actually explained that to the extent that he did not provide an answer for that, it means that that threshold too was not satisfied. So they had to go ahead to do some other analysis.
Okay. So what does this leave us? And we know that the committee is in place. They are also, undertaking their own investigations and processes. What does this mean for the committee and for, the general public who are following this issue? So
in essence, this matter has long been settled. It's long been settled because the purpose for which Vincent went to court has not been materialized. This application has been dismissed, except to say that there is still the substantive suit which stands, for which the court will now have to do an interpretation of the provision specified. So when you read the judgment carefully, the court is careful not to go into the arena of the substantive suit which talks about the interpretation, but just to make a case for why they do not think at this point it is prudent for the court to have halted the processes altogether.
Okay.
So the process is still ongoing, but remember, even subsequent to this, there have been other attempts to still injunct the process. And that is a matter that the court has still stood firmly, except that in that particular instance, with a differently constituted panel, the decision was 4-1 majority. But it's also instructive to put on record that in Justice Yoni Kolendi's concurring opinion, even though it is not straight to the matter, there was an issue that Vincent was making. You recall that when he filed the petition, at the time, the prima facie case has not been determined yet. But by the time they heard the application itself, that was because the court had to adjourn twice. There was a determination of a prima facie case, a committee had been established, and then the Chief Justice has actually been suspended. So he makes the argument that even though he had filed an injunction application and served on the Attorney General, they still went ahead to do all those things, and that was in disregard of the court. He was coming on the back of a popular notion in the minds of many lawyers. It's actually a controversy as to the question of whether when an injunction application is served on somebody, it operates as an automatic stay. Justice Yoni Kolendi took his time to analyze that principle and to say that he wants to put things to bed. He did indicate that they cannot allow that principle to operate, so that if just by merely serving an injunction application on a constitutional body or a government agency, then it has to operate as a stay. Because if we were to allow that to happen, people can just go to court and serve frivolous injunctions. That will bring government business to a standstill. So he makes exceptions for the constitutional bodies and then some government organizations. And he says that when it comes to matters like that, it has to be dealt with on case-by-case basis.
Okay.
In law, we say this is an obiter. It means that it is not the matter in dispute. However, it is incidental. So having said this, it could serve as a guide moving forward as to whether the service of injunction applications on persons operate as an automatic stay or not. Martin, just to wrap up, the dissenting opinion, which was written by Professor Henrietta Mensah-Bonsu, she takes a different view altogether to say that, in her view, the sequence was not followed properly. And to even
which is largely more or less in agreement with Vincent Esikfo.
To say that because the petition announcement was made, even it got into the media, and that we did some analysis, part of which were coming hard at the judiciary, and that in all of that, it did not present a clear picture for anybody who was performing the function of having to assess the thing to come to a conclusion of a prima facie case to have a proper or a fair mind to do so. And in her view, that even the announcement was made way before the Chief Justice got the petitions. She also makes the case, referring to the arguments that were made at the Attorney General, that when the Attorney General was asked the question of the sequence, he seemed to suggest that a sequence does not matter as long as you are giving the petitions. But she is of the view that no, this is a quasi-judicial matter, and for which reason the sequence is very important, especially when she had to respond to something, and that it does not show respect to the judiciary, especially a member of that standing, to only get to hear about something of that sort in the media without the benefit of having copies of it to respond to it. It was on that basis that he and she and Justice Jewu departed from the majority. Okay. So in essence, that's like the crux of the whole matter and the reasoning of the justices of the Supreme Court as regards this injunction application.
Okay.
What still outstands is the substantive matter, which they haven't indicated when, but clearly they indicate that it's still a matter that they will look at.
Okay. Right, Dennis, thank you so much for walking us, giving us, some law lecture 101s, trying to break down the documents or the reasoning of the Supreme Court, following Vincent Isifua's attempt to ask the Supreme Court to halt the process of the suspension of the Chief Justice right from the get-go. Let's get some further legal analysis on this. Christian Hesimam is a private legal practitioner. He's also joined us for quick thoughts on this. Good evening, sir. Thank you for joining us.
Good evening. Thanks for having me to your listeners.
Right. Let's pick up from the two judges who dissented, and for instance, they are of the opinion that the immediate fact of the government communications spokesperson coming to speak to the public or tell the public that some petitions have been received by the president, and on the back of that, the Council of State has been notified to start taking action, that in itself contravenes the laid down procedure or the processes. Is that a fair argument to make, you believe?
Indeed. I mean, a close look at Article 146 indicates that when such situations happen, received by the president, it is transmitted to the Council of State, and in tangent, a prima facie is determined, even though the word prima facie is not captured therein, but by filling in the gap, Justice Dateba filled in the gap when he had the opportunity in the Chum versus Attorney General case. Indeed, espousing further in the Chum versus Attorney General case, the learned justice further went on to say that petitions cannot be disclosed. In terms of the content, the disclosures cannot be done. We remember when Bright Akwete initiated similar matter against the then Chief Justice. That's when the learned justice had the opportunity to eruditely opine on these matters and made a lot of recommendations to amend Article 146 or furthermore, the Rules Committee put in procedures to create a certainty as far as that area of procedure is concerned. Now, having gleaned that enormous and erudite judgment, it never touched on the fact that when the petition is brought or is filed, it cannot be made mention that a petition or petitions have been made. But what it indicates is that the content of the petition need not be disclosed. And by constitutional interpretation, that is basically that happened. The contents of the petition had never been. And if you look at what has happened so far, that's it. So I beg to differ a little as far as considering Justice Dateba's position in that particular Supreme Court decision is concerned, just opposing it to the facts as we have it. Yes, I mean, the Supreme Court as a body, by style decisis, can always depart from a position, but that position must be by a majority reasoning, and it doesn't appear as that. So it still remains that, yes, the content of the petition must not be made known to the public. It must be concealed. But as to who has filed a petition against the Chief Justice can copiously be made known.
Right, and still on the back of that, I mean, the other side of the argument that by virtue of simply announcing to the public that the president has received petitions against the Chief Justice, that in itself allowed people, including lawyers and, the general public, to share their thoughts and opinions, which could influence whichever final outcome may be arrived at. So does that hold water, saying that although the content of the petition has not been made public, the mere mention of the fact that a petition has been brought against person A or person B in itself could, influence those that may have to take the ultimate decision after investigations, are carried out?
Again, the use of the word could means that it is subjective and it is not from the objective point. So that once it is could, it is not factual and it is not conclusive. So it gives room in law for one to conjecture. And that is basically having read nuggets of the decision that covers this area suggests to me, and it would not surprise me that most legal scholars would hold that, because once you use the word could and you keep going in that area, it means it's subjective. The fact that a lot of pundits have mentioned things out there does not necessarily mean that the mind of persons who are in charge could be compromised. It could be, it could not be. But as to what the true thinking is, which went through and which had been employed to arrive at this particular conclusion, should be one of facts and not one of conjecture. So again, with that one too, I beg to differ.
We are grateful for your thoughts and time this evening, and thank you so much for speaking to us.
Thank you so much for having me.
And you heard the thoughts of, fine private legal practitioner Christian Hesimam, who has been also, trying to give us some education regarding the final judgment from the 3-2 decision of the justices of the Supreme Court, when they dismissed the application by Vincent Akosifua, on the back of the fact that he wanted the entire process initiated by the president to remove the Chief Justice or to ask for an investigation to be undertaken into the Chief Justice or accusations of the petition against the Chief Justice. Vincent wanted all of that halted because he thought that it had, the processes had been altered by how the procedure or the sequence of events played out. From the look of things, the judges, by a 3-2 majority decision, dismissed it, thinking otherwise. So if you want details of the reasoning, the 81-page reasoning, you can find that on our website, 3news.com. We're staying on the issues of the Chief Justice because on the 22nd of April, which was Tuesday, Ghanaians were informed of Chief Justice Gertrude Torkornoo's suspension following numerous hints leading members of the NDC on social media. Spokesperson to the President, Minister for Government Communications, Felix Kwakye-Fosu, in a statement announced that a prima facie had been established in respect of 3 petitions calling for the removal of the Chief Justice, and a subsequent committee had been set up to look into the allegations. Lord Eduasari assesses changes that have occurred at the Judiciary since the directive.
Hours after the suspension of Gertrude Torkornoo as Chief Justice, Justice Paul Bafo-Boni, a Justice of the Supreme Court, was appointed acting Chief Justice in accordance with Article 1446 of the 1992 Constitution, which mandates that the most senior Justice of the Supreme Court shall act in the role of Chief Justice when the position is vacant or when the incumbent is unable to perform their duties. As his first move as acting Chief Justice, Paul Bafo-Boni instructed that all newly filed cases be forwarded to him for assignment and scheduling. A circular signed by the Deputy Judicial Secretary indicated that the acting Chief Justice would assign courts and empaneled judges for all the newly filed cases and applications. The directive has since received backlash from the Ghana Bar Association, with the latter issuing a statement calling for the revocation of the order. The acting CJ also directed Dr. Serakus Baninye Bapuro, the Deputy Judicial Secretary, to assume the position of the Interim Judicial Secretary subject to the eventual decision by the Judicial Council. The memo from Justice Bafo Boni followed the resignation of Justice Seka Pamela Karanting from the role. Hearing of the injunctions against the suspension of Chief Justice Gertrude Torkornoo was chaired by the acting Chief Justice Paul Bafo Boni. On May 6, the Supreme Court resumed hearing the injunction application seeking to halt the suspension of Chief Justice Gertrude Torkornoo. Justice Bafo Boni empaneled new judges, with him presiding over the matter. A former Attorney General, Godfrey Dame, who was the lawyer for the plaintiff, objected and asked the acting CJ to recuse himself, citing that he stood to gain from the result. The objection was eventually overruled and dismissed. The acting Chief Justice has since empaneled himself in subsequent constitutional matters heard at the Apex Court. Administratively, some judicial service staff have also been reassigned to other departments.
And you hear that report put together by Lord Edwards, our court correspondent. This is still 3FM 92.7. You're listening to Hot Edition, live from our studio here at Adisanwe in Accra. Do let your messages come in and let us hear your thoughts on the